case on the docket, which is Grable versus Grable, 24-3224. Counsel for the appellant, you may proceed when you're ready.
Thank you, Your Honors. May it please the court. Welcome, Judge Treadwell. I'm Diane DeWolf for the former husband, appellant Stephen Grable. Your Honors, this is a very straightforward appeal. We have two issues on this appeal. We have case law that supports our argument 100%. Those two issues are an equitable distribution payment that's been delayed for 18 years. And the second issue is alimony that's inflated well beyond the former wife's need. And I'll take each one in turn. The trial court has discretion in how it fashions an equitable distribution payment. But it abuses that discretion when it postpones that payment for 18 years. We cited three cases directly on point on this issue. That's Harper, Thomas Nance, and the Gooder case. And all three of those cases say that there can't be a contingency on this payment, and we can't drag it out for decades. I think in the Harper case, it was a home equity of $25,000, where the court ordered payments for 20 years of $100 a month or something like that. The courts have held that that's patently unreasonable, and that's exactly what's happened here. Now, former wife has tried to distinguish those cases by saying, well, in those cases, there was a small payment that was made every single month. Well, here we have no payments being made every single month, and we have a huge contingency on whether this is ever going to be made at all. First, former husband has to be around long enough to get to stop making alimony payments. Former wife has to be around long enough to do that too. And alimony is a fluid concept, right? So that it changes over time. It would have to stay exactly the same for 18 years. So I don't really know how you get around those cases. I don't think you can. And there are many ways to fashion this equalizer payment besides tacking it on to the end of alimony payments 18 years from now.
Well, let me ask, in terms of what the trial court's discretion is, is it your position that the trial court could have offset alimony the first 3 years as opposed to the last 3 years?
Well, that would probably be a little bit more reasonable. I don't think he could do it for an entire 3 years without also adding an interest component to that. So, right now, we are at, a year out. This is a November 24 order, right? Statutory interest in 2024 was 9.5%. So it's no longer 103 if we go by statutory interest. It's 113.
So what is the statutory basis for your argument that interest is an entitlement for this type of distribution scheme?
It's not an entitlement, and it's not a statute, but the cases that we've cited, this was also mentioned in Harper and also in Thomas Nance. If you're going to drag payments out, first of all, it has to be a reasonable amount of time. It can't be 18, 20 years like we have here, right? So it has to be reasonable. And you have to consider the interest component. Maybe interest, if it's going to be paid in 6 months or something like that, maybe interest isn't a component. But I suggest to you, when it's going to be dragged out after several years, there ought to be an interest component, and the case law supports that.
I'm just wondering what the basis in law is for the interest component.
Yeah, I don't know that that's in the alimony or the equitable distribution statute. I don't know that it's actually in there with the interest component, but the case law does support that. And Harper talks about interest, and also Thomas Nance.
So in 2018, the legislature did add a provision, subsection 10B, that discusses if installment payments are ordered, the court may require security and a reasonable rate of interest. Does that apply here?
I think it does. And again, it's a may, so it's a discretionary. So I don't think it's set in stone. But certainly, if you're going to have payments that, take 2 decades, and even 3 years, as you suggested, Your Honor, there should be an interest component. And again, as I was saying, there's several ways to fashion this. Former husband very reasonably said, let's just, instead of, leave my vector security account, let's not do it half and half, It's $103,000, so you take $103 less. The vector security was $400, so I'll take $303 and you take $97 instead of $200 and $200. But the the court didn't do it. That wouldn't have been any money out of pocket to the former wife. But, Harper says there's any number of ways you can do this. You can require a home equity line of credit. You can require a second mortgage. You can require them to take out any type of loan to pay this. But the point is that it has to be paid, and it has to be paid now, not 18 years from now.
So to what extent does the court abuse its discretion by commingling this part, the equalizer, with alimony? It seems to me that they're separate and distinct, and maybe that's kind of the rub here, is then when you commingle it with alimony, it gets complicated.
It is complicated, and it's even more complicated if the alimony payments ended early for some reason, right? Because then the equalizer payment never gets paid, and you say, well, but the alimony ended early, so then you didn't have to pay as much alimony, and that's not the point. You still have an equalizer payment of $103,000 that's owed, and it was owed back when the final judgment was entered. It's not owed 20 years from now, whether or not, alimony lasts that long or not. So, very good point, Your Honor. No, it shouldn't have been commingled. They're two completely separate things. So we would ask on this issue that you reverse this equitable distribution scheme and order the trial court to fashion something reasonable where this gets paid in a reasonable amount of time with interest. Regarding the second issue, we have a $3,000 a month alimony payment that was ordered here that is at least 2 times and possibly 3 times beyond the former wife's need. Now, we know that before the final judgment, former husband was paying $1,140 a month in alimony that was later memorialized by the court. It was first voluntary, it was memorialized by the court. And former wife lived on that for a couple years. She did try at one point to come back and get $3,000 a month, and the court said, no, you haven't proved that you have a need for that, and he refused. And since that point, former wife hasn't gotten any more expenses. She doesn't now have a mortgage. She doesn't have any debt. There's no credit card debt, none of that. She got a raise, $3,600, but now all of a sudden, she's established this need for $3,000 a month, and I would submit to you that is not a need, that is a want. And we went through all of these in our brief, and I'm happy to go through them quickly again from her financial affidavit. I mean, and there's several items in here, and these were all brought before the trial court too, who just brushed these aside. But one, she lists $180 a month for health insurance payments, which is the premium for the entire family, adult children, and the former husband. The actual health insurance per month is $50 now, and she conceded that, and that's in the testimony.
Is it still your position that Mr. Grable should not be paying for the adult children's health insurance?
Well, this is coming out of, this is state coverage, so yes, she's welcome to pay for the adult children's, but that shouldn't be credited as a monthly expense. That's a voluntary. And the $180 covers the entire family, including Mr. Grable. We have these $383 for monthly repairs and maintenance on the home. Again, if you look at that, the only thing that was talked about, one, was the house needs a new roof and a shower repair. Okay. But we all know that the value of the home was $290, and that wasn't from Zillow. That wasn't some, made-up number. That was a home appraiser that came to the home and did a home appraisal based on the shape the house was in at the time, taking into consideration that the roof needed repairs, right? So if the roof had been repaired, the house would have been valued at more than $290,000, and then the equitable distribution payment would have been that much more, right? Because she would have had a house valued at $300 and not $290, so she would have owed more. So, but she's added this, and it's completely speculative, and the case law says you can't do this either. You cannot have speculative expenses, and this is in the Dorworth case, and this is also in the Flans case out of this court. This is completely speculative. We have $383 per month for home repairs every month for 18 years, which at the end of the day is going to be $82,000. It's completely speculative. That's not a new roof. That's a
How
swimming
do
pool.
you make sense of the letter from the insurance company demanding a new roof? I mean, how can you say a new roof is speculative on this record?
What I'm saying is $383 per month for 18 years, adding up to $82,000 over 18 years. That's speculative. A new roof was already taken into consideration by the devaluation of the home to $290. If it already had a new roof on it, she would have been credited with a higher amount. That means that her equitable distribution payment would have been more.
How can we as a court ourselves speculate as to what something's value would be if a repair, would be made? Don't we have to take the present value of an asset and the equitable distribution side of the calculation?
I'm not asking you to speculate at what the value of the house would be with a new roof. My point is that the house was valued as it was, needing a new roof. So if she didn't have to do that, the value of the home would have been valued much higher. Does that make sense? I know I feel like I'm saying the same thing over and over. I'm trying to say it differently so it makes more sense. But she would have had a higher value asset on her side, okay?
Right, and I guess in the alimony calculation is what is the former wife's need, right?
Right.
And so is your position, had the, I guess, estimate of a home with a new roof been included, then the former wife wouldn't have that need? I mean, in some ways, I understand sort of your double counting argument, but at the same time, like, if she has to come out of pocket for a new roof, why wouldn't that be part of her need?
Because she got a devalued asset in the equitable distribution because she needed a new roof. Because the home needed a new roof. And either way, we're still looking at $82,000 in home repairs over the next 18 years, which is, that makes my eyebrows go up. It should make yours go up too. The next category was car repairs. Now we know that she had $4,500 worth of car repairs during the dissolution process, and that was not credited against her. $45 went to fix the car was fixed. So now she lists as a monthly expense, $398 per month for car repairs. The car's not broken. I don't know how else to say that except that it's speculative. We just have no idea, and no one should be spending $400 a month on car repairs. And again, over the course of 18 years, that's $86,000. So that's not repairing an old car, that's buying a Mercedes. Again, these are wants, these are not needs. And the trial court here, he took every one of former wife's listed expenses as gospel. He didn't question any of them.
Were they all objected to?
They were all objected to,
Okay.
yes. Even the food was objected to. I mean, monthly grocery bills of $850, that's for eating in. Then another $466 for eating out, that's $1,350 for a single woman per month. And none of this was questioned. And then the trial court said, that's probably not enough. I know that on your paper you say you need $27.14, but let's go ahead and round it up to $3,000 because you might have more expenses. So he gave her an additional $286 to boot. So if we take away the speculative expenses and the clearly inflated expenses, and we take into consideration that the former wife was living just fine on the 1140 for 2 years, and the court at that time found that she had no need to increase the expenses, with the increase in salary and no additional debts, it's just not possible that she needs, 3 times that much now.
Going back to the car repairs, I am curious how each repair in your argument is not, supported by competent substantial evidence. So, the first one I think that the former wife testified to was the catalytic converters. So she mentions that repair had already been made and was, an expense. How is that I mean, not competent substantial evidence as to
Oh,
what her car needed.
it's competent substantial evidence as to what has already been done. We don't have any objection to that. So her car needed repairs. It was $4,500 worth of repairs. Those were made during the dissolution process. That was not credited or debited to either party. That was taken out of the joint account. It was paid. What I'm saying is speculative, is she has included, for alimony purposes, for the next 18 years, $400 per month. That is $4,700 every single year for the next 18 years to repair a car. It's one thing to say, and that's speculative, okay? Because maybe the car never breaks again. Maybe she decides to use Uber the rest of her life. You know, maybe she never gets another car. Maybe her parents give her a car, right? We don't know. It's one thing to say, I own a car, and my monthly expense is, you know, for my car payment is $350. That's one thing. That's something that's tangible. That's not speculative. But to say for 18 years it's going to cost me $400 for repairs,
Where
that's
are we
speculative.
supposed to draw the line in terms of, all right, an abuse of discretion standard, where are we supposed to draw the line? I believe the wife testified that she divided the house expenses over 5 years and the car expenses over 3 years. Where do we draw the line in terms of, you know, what amount of time is an abuse of discretion in terms of what you argue is inflating expenses?
Well, I think you really have to look at the case law and see what is speculative. It can't be an anticipatory expense. What she's saying is, I anticipate that I'm going to have to repair my car. But she doesn't necessarily have to repair that car. She may not have any car. You know, maybe we all go to public transportation in the next 5 years, right? So that is speculative. And the case law says you cannot do that. You have to have tangible, and again, it's the example of, I have a car, I have this payment. I have a mortgage, I have this payment. I have, you know, this is how much I make. Those are tangible things you can do. But alimony cannot be based on these speculative expenses that may never come to fruition. She might sell the house. She might never put on a roof. She might never have a repair. She might move in with her parents. These are all speculations, and that's where you have to draw the line.
Since you mentioned, you know, how much does she make, let's talk about the income piece. Why should we use sort of half the equation when, you know, she testified there in July at the final day of the hearing as to her then current income, or at least gross income? Why should we use that figure rather than the gross and net that she previously testified to on one of the earlier days in the hearing?
Because she got a raise. And we're calculating alimony from the final judgment. And between that hearing and the final judgment, she received a $3,600 increase. And, you know, that's not speculative at all. I mean, you all know as state employees, your salaries are online. My salary, when I was a state employee, it was all online. You can look online and see what anybody makes who works for the state at any given time. So there's no speculation about that.
It seems like the parties, you know, there is no record evidence as to her net income there at the final day of the hearing, right? And so that's why there was this argument about what tax rate applies. At what point should we, you know, say, okay, the trial court has cut off the admission of evidence, and so we use what's fully in the record in terms of net income versus, you know, did the trial court have a duty to keep the record open, to get a first pay stub? I mean, help us sort of analyze this issue in terms of the record closing.
Well, she was asked at the hearing, did you receive a raise? Is this now your salary? And she said, yeah. So I think all those numbers are fluid until the final judgment. And I see I've almost depleted my time, so I will save my minute
Thank you, counsel.
for rebuttal. Thank you.
May it please the court. My name is Eric Schopp, and I will be presenting argument today on behalf of the appellee, Melissa Grable. I'm going to be presenting argument in the same way that the briefs are structured. I'm going to start out by addressing the appellant's challenge to the equitable distribution, and then move on to the issue of alimony. When it comes to the distribution, the appellant's only challenge to that is the method of the payment of the equalizer that the court fashioned. I think the case that really is this court's guiding light when reviewing the reasonableness of that payment method is the Kanakeres case from the Florida Supreme Court in 1980. I trust this court is very familiar with that case, but it essentially describes the parameters of the trial court's discretion in dissolution of marriage cases. Essentially, the Supreme Court described that so long as the trial court's decision could be considered reasonable in light of the evidence presented, then the trial court did not abuse its discretion. Where I quoted specifically from that case in my brief was where the Supreme Court said, dissolution proceedings present a trial judge with the difficult problem of apportioning assets acquired by the parties and providing for necessary support. The judge possesses broad discretionary authority to do equity between the parties and has available various remedies to accomplish this purpose.
So counsel, thank you for refreshing our memories, and we are very familiar with that case and those principles, and so certainly discretion is always bound by the law. So let's focus on the law. In terms of equitable distribution, the equalizer payment was due immediately, or became due immediately, correct?
I would agree with that.
So how do you reconcile that with this idea that it somehow becomes commingled in alimony, which in some hypothetical situations, it could never become due?
If you'll let me finish my quote from Kanakeres, I'm getting right to that exact point, because what they go on to say is that these remedies are interrelated. And so it's important when an appellate court is reviewing the trial court's decision to review that as a whole and not to kind of look at
Counselor, Kanakeres was decided in 1980. The legislature passed the equitable distribution statute in 1988. So is on that point, if there's a conflict between the equitable distribution statute and Kanakeres, which one should win out?
The statute would govern. As I understand, when that statute was passed in 1988, it essentially codified Kanakeres. That was the intent of it. And obviously that's been built upon and developed in the 30-odd years since then. But yes, the statutory authority, I agree, would govern over Kanakeres. However, as a principle of law, I think that is still kind of the guiding light behind the court in this case. Now, to get to Judge Ray's point, and I'm sorry I took a little detour on the answering the question there, I just fundamentally disagree with the characterization put out by the appellant that he has to wait 18 years to receive his equalizer in the way that this was all fashioned. And I can get through the process of how we got to this point in the record of why, the court chose this payment method as opposed to other payment methods. But I really think he's already gotten the benefit of it in the form of an alimony award that is shorter than what it would have been, and is also probably less than what it would have been otherwise. Because when you go through some of these other options that the appellant has put out there, the trial court could have done this, they could have ordered this. There are very specific reasons why in this particular case, those options really weren't available to the trial court based on the arguments that the parties made and the evidence that was developed on the record at the trial. And really, when you got down to it, by the time we got to final hearing, the only two options available to the court were to do some kind of an offset of Mrs. Grable's alimony award, or essentially require her to pay all of it immediately, which probably would have required her to take out some kind of a loan or go into debt because she wasn't being awarded the liquid assets to be able to make that kind of a payment, which would have then increased her need for alimony by the amount of the loan payment, right? Because if all of a sudden she's got to take out a debt in order to pay Mr. Grable his equalizer, well, then that's kind of circular, isn't it? It's going into a situation where he might end up paying his own equalizer in the form of an increased alimony obligation based on the issue of her increased need. So to give you an example, one of the options put out there on appeal by Mr. Grable as what the trial court could have done as opposed to what he actually did in this case was require the home to be sold. Well, that wasn't really a realistic option for the trial court in this case. First of all, neither party pled for partition in the actual pleadings themselves. And then second of all, from the very first day of trial, at opening statement, it was stipulated by both parties that Mrs. Grable was going to be awarded the house. We didn't know exactly how things were going to fall around that, but it was stipulated from the front end. I think if the trial court had departed from really what both parties were putting on the record as what their position was and asking him to do, that would have created more appealable issues with the equitable distribution scheme than what he finally did. Another topic brought up today by opposing counsel was the idea that there could have been an offset. Maybe my client could have taken a little bit less from the 401k and had that paid immediately rather than doing what the trial court ended up doing in this case. And I thought that was an interesting suggestion because you'll see in my brief, that was actually our position on the very first day of trial, was as a starting out point, was we were actually proposing that as a solution to deal with that problem. However, what ended up happening is after the first day of trial, Mr. Grable hired an expert accountant to testify about the retirement accounts, how they should be divided, and specifically issues with tax consequences, potentially valuation of my client's pension, and things of that nature. And what that expert ended up recommending that the trial court do by the second full day of trial, which was in March of 2024, was divide all retirement accounts evenly on a pre-tax basis, and then handle the rest of the distribution separately. The trial court ended up going with that accountant's recommendation, and my client, or Mrs. Grable, did endorse that at the last day of trial when she testified on rebuttal. But when the trial court decided to adopt that approach, it really removed the retirement accounts from the rest of the distribution. And then so there really wasn't another asset like that that could be kind of used as an offset. And when that happened, it created a situation where we really weren't able to do an offset against some other piece of the distribution. And then we were left in this situation where there were really only the two options of Mrs. Grable incurring some kind of debt, getting into this problem that I talked about already, or doing an offset against alimony. As I raised in my brief, the position suggested by both parties to the trial court was an alimony offset. The difference in what we were proposing was not one of character, it was one of degree. The appellant, in his proposal to the trial judge was just saying, look at that as a lump sum payment of alimony and then nothing else is owed since then. We'll do that as an offset there. Our position was that could be an offset against a portion of the alimony award, but it's not an offset of the entire award. So the trial court really took the approach that both parties were advocating for at the trial level. Now, he ended up closer to the appellee's position than he did the appellant's position overall at the end of the day, but I don't know how you could argue that the trial court acted unreasonably in adopting this particular approach when it really was something that was in the middle of the two different approaches that were being put forward by both of the parties. So when you look at it...
It makes sense how we got here. I mean, the story makes sense. But in terms of our review, in terms of the abuse of discretion standard of what is now before us, I mean, would you agree that if your client were to remarry or pass away, that there's a likelihood that the appellant would not receive any of the equitable distribution?
Well, I think this kind of gets into your first question that you asked the appellant at the beginning of the oral arguments, which is, would you say that there was a problem if he got paid up front, whether getting paid on the back end, and how some of that was kind of worded in the court order? My position is he's already been paid, in a sense, in that, you could look at this as just a lump sum award of alimony is basically wiping out the equalizer, and then the durational alimony award is shorter than it otherwise would have been and lower in amount than it otherwise would have been. So if he's already been paid, I really don't think there is any danger that he would go without his equalizer. Whereas the appellant is trying to frame this as he's not going to get paid or be compensated for this for another 18 years. And I just disagree with that characterization.
If your client remarries, let's say at year 12, what does it matter whether the alimony award is 15 years, 18 years, or more? I mean, obviously, the cap is 18 years, but what does it matter? I mean, how could you say he's already been paid if your client remarries at year 12?
Because, so for example, if he were to be, if we were in a world in which my client was required to pay him the equalizer up front, borrow a loan, take out the money to actually do that and start paying him. Let's say his alimony award was $3,500 a month rather than $3,000 a month, taking into account her increased need to have to do that and, taking into account that there probably would be interest paid on that if it's a loan through a bank. So every month so far that he's been obligated to pay $3,000 a month as opposed to, say, $3,500 per month to account for what her need would be with that loan payment, he's effectively getting the benefit of the alimony award that the court actually did fashion.
And maybe just to jump off on Judge Treadwell's question, though, this again, it shows the complications with commingling the equitable distribution payments with alimony. It gets complicated, and no matter what hypothetical scenario we throw out to you, I think it becomes problematic. So why isn't that in and of itself an abuse of discretion? Maybe you've answered the question that both parties suggested to the court, that alimony be fashioned in some various ways to accomplish the equitable distribution. Is that correct?
That's part of my answer to that question, Your Honor, is that I do think, when both sides are suggesting, an alimony offset is a reasonable way of accomplishing the equalizer, then you're looking at this from a standard of, okay, could reasonable minds disagree on whether or not this was the right course of action to take? I think that answers that question right then and there, that clearly reasonable minds could have thought that this was the approach that the trial court should have taken, because really both parties suggested it to the court. It was what he ended up doing was something that was a mix of what both parties had suggested. So when you're looking at it from that abuse of discretion standard, I don't see how you say that the court abused its discretion when it really adopted an approach that was along the lines of what was offered to it by both parties.
I did not see in your briefs a position on the interest argument.
Well,
Care to
I don't think you
comment
get
on that?
into the interest argument if you just affirm the trial court's position as it is. Now, I would agree with Ms. DeWolf that in a world in which the trial court instead ordered my client to pay $103,000 to Mr. Grable in monthly installments of $500 per month, he would have also had discretion to award interest on that payment. But since we are taking the position that the trial court's ruling should just be affirmed as it is, I didn't see a need to get into that argument specifically. But I do agree that if there is a different distribution scheme, depending on, say, remand or something, then it would be appropriate for the trial court to consider statutory interest.
Great. All right, the alimony issue.
All right. I'm going to move on to the issue of alimony then. So on this issue, the appellant challenges really two of the trial court's findings. The first is related to Mrs. Grable's income, and then the second is related to her monthly expenses and her need for support. So I'm going to go through them in that order. Again, I think the guiding light here ultimately goes back to Kanakaris, but the case that I cited in my brief on this, I think it's called Theriault, I think I'm pronouncing it correctly, which is out of the first DCA in 2012. It's citing Kanakaris, though. And what it generally stands for is that this court's decision should be affirmed if it's based on competent and substantial evidence and does not cause either spouse to pass automatically from misfortune to prosperity or from prosperity to misfortune. So I think that's kind of the guiding principle here for evaluating whether or not the trial court's decision in all of this was reasonable. So as to Mrs. Grable's income, I think it's important to review the timeline of the final hearing itself. We were originally set for a full day final hearing at the end of November of 2023. We did not finish that day, and so 2 hours were reserved in December to finish up the trial. During that time, the appellant decided to hire an expert. And so that caused a delay of the final hearing until March of 2024. Again, we did not finish that day, and so the final portion of this was set for July of 2024. During the July 2024 portion of the hearing, Mrs. Grable testified in rebuttal to some of what the appellant had been presenting on the record, regarding the various issues in the case. During cross-examination of that rebuttal testimony, the appellant's attorney asked Mrs. Grable some questions about a raise that she had received about a week before the last day of the final hearing. She didn't even have a pay stub yet, regarding what all of that looked like. There was no concrete information presented as to exactly what that gross amount was. The attorney for the appellant at the trial level just put out a number, and my client said that sounds about right, I think was about what the transcript said, but kind of equivocated on that, and there was absolutely no evidence presented as to what the actual net income would be. The trial court, in its discretion, based both parties' incomes on their 2023 income information. That decision makes sense, given that it had the most accurate and complete information for that year. What appellant is suggesting this court should have done is conducted its own independent research using publicly available information to get an exact figure for my client's income as of the last date of the final hearing, and then either come up with its own math to figure out the net income, or sua sponte, because no party actually requested this, continue the final hearing to a 5th day to allow additional discovery to see what the actual net income would be and additional discovery on that issue. I think the sound approach here was the one that the trial court took, and it based the parties' incomes on the actual record before it, the 2023 data, which was current as of the time the trial commenced. I think there actually would have been more appealable issues if the court had gone outside the record and done its own research as suggested by the appellant.
So within the record, and I'm looking at page 1458, within the record, the question to your client was, can you verify that your present income is presently $46,456 annually? Answer, that is probably correct, yes, sir. So if your client is acknowledging that her income is different than what's in her affidavit and what's on the pay stubs that were previously, admitted into the record, why wasn't it an abuse of discretion for the trial court to use the outdated figures, at least on gross income?
I think her exact quote was, "It is 46 something." So that sounds right, yes, sir.
So that was the colloquy with the judge on page 1459. But if you look at her initial answer with 1458 before the judge got involved, I mean, that seems like an unequivocal acknowledgement, admission. That is probably correct. Yes, sir.
Mm-hmm.
And even if her testimony was simply, yes, it's now 46,000 something, why wasn't it an abuse of discretion for the trial court to still use a $43,000 figure?
Well, because the court had the actual net income figures from the 43,000, the earlier figure, which net income is what you need to use for alimony purposes, and establishing that figure. It had no information about what her new net income was, even though there had been this raise.
Have circumstances changed since then? Either
Since
side? I mean, if we send it back, is it a do-over? I mean, are we still using the old numbers? They get a chance to put on the new numbers, everything's different. We do it again, we see you in 18 months, what's going to happen here?
Well, I think that was the trial court's concern, was that this trial had already been ongoing for about 8 months at this point, and rather than kind of leaving the record open, and I'm not sure to what extent this is in the record, but we had actually filed for additional discovery from Mr. Grable in the month of January. We filed a motion to compel, the court denied it. I think he was trying to close the record to kind of just get something that was static in time, to try to, have that to calculate alimony, because these numbers do fluctuate.
I mean, and that's inherent in the process, for both sides. It's just the way it happens, but yeah.
So I think, obviously if you were to go on remand, probably the numbers would look a little bit different today on both sides. I'm not, necessarily arguing that, but I think at some
And
point.
nobody's stuck with the old numbers, provided that they provide new numbers, if there's a do-over.
Right.
Okay.
The next and final issue is my client's estimated expenses for various things that the trial court used to calculate her monthly need for alimony. And when I first read through the appellant's argument on this point, I felt like he was talking out of both sides of his mouth. On the one hand, he's arguing that the trial court shouldn't have looked backwards at an average based on past expenses because those had already been paid. But then on the other hand, he says you can't look forwards to reasonably anticipated future expenses or events. I mean, by his logic, I feel like the trial court would have had to have boxed Mrs. Grable in to the date of the final hearing and only counted the bills that were actively due on that date and time. I see my time is coming to an end here, so just to kind of wrap this up,
Well,
I do
counsel,
think.
I'll extend your time and then provide
you.
the same courtesy to appellant's counsel. I do want to just ask about these additional home repairs and maintenance, the roughly $286 a month that were kind of added on. Do you concede that there was some double counting there based on what was already in the affidavit, or do you see a distinction?
I believe there is a distinction there, and I think what's also important for this court to understand is we had done 3 different financial affidavits over the course of the case. Most of those had figures over $3,000. The most recent one was the one that had the figure with a number that was a little bit over that. From the first day of trial, though, my client testified to a need of $3,000. What's in her financial affidavit was based on, certain reasonably foreseeable expenses. There was testimony about the average and how she kind of got that number there. She also presented testimony about various different unexpected expenses that had arisen while the matters have been pending. I think there was a garage door repair that was testified to during the course of this, and some of that is what is informed in that additional number that got us from the number that's on her financial affidavit to the $3,000 that was ultimately awarded by the trial court. So I don't think it's double counting. I think it's kind of, these were specific itemized things, and then there was kind of but there were more things
But like a
that I
catch-all,
wasn't
something like
anticipating and
that.
wasn't counted. That's, yes.
Yeah, so the trouble as a reviewing court is we're tasked with connecting the dots, and it's really hard for us, or at least for me, to connect the dots when we have kind of this catch-all sum that at least on paper, based on what I can see, there does seem to be some redundancies. So I guess I'm just, stating that proposition that I'm having a hard time not seeing some redundancies, at least with respect to that extra amount that was added on.
And I think that's where we get into the Knackers case, as quoted by the first DCA and Theriault, that I started this whole portion of the argument out with, which is, a lot of the appellant's argument is kind of digging in through little expenses and trying to see exactly if all the numbers add up or not, or this or that or the other thing. But I think the standard that this court needs to kind of look at is there competent and substantial evidence in the record to support what the court ultimately ended up doing? And is it an award that, doesn't, immediately move one party from being impoverished to prosperity or vice versa? And I think the court's ultimate award here of $3,000 per month in alimony is in that middle ground of, kind of giving my client the support that she needs to live with some standard of living comparable to what was, she was accustomed to during the course of the marriage, while also not being so burdensome on the appellant that he's now at this reduced standard of living where he can't live the same way that he did before. I think the court's award here is in that middle ground, and so I think it is within the bounds of his discretion, regardless of...
Sorry, on the additional home expenses, and you mentioned the garage door that happened,
Yeah.
pending the final hearing's conclusion. How should we sort of read the colloquy here on record page 1429 between the court and trial counsel for the appellee, where the judge is inquiring about the affidavit? But what I'm trying to get at is when the wife sat down and did what she thought were her expenses, was she thinking, no, it should include reasonable expenses for breakage of things, roofs and water heaters, things that happen? Trial counsel answered yes. So is there competent substantial evidence to suggest that what she put in her financial affidavit is not all-encompassing of every house repair that, may come about?
I think there is competent substantial evidence. I understand the exchange that you're talking about right there. However, I think there is plenty of testimony actually in the record from Mrs. Grable during all of the final hearing about additional expenses, on things that she didn't foresee when she prepared that financial affidavit that were included and kind of factored into that $3,000 number.
Thank you, counsel. Does the court have any additional questions? Thank you.
Thank you all so
Appreciate it.
much.
2 quick points, Your Honors. Both sides did not suggest that this come out of alimony. The only argument that former husband made regarding alimony was, hey, you owe $103,000. Why don't you just take it as lump sum alimony, and then we'll just wash our hands and be done. No one suggested that it should be over a 3-year period, or at the beginning or at the end, or anything like that. So no, this was not an argument made by both parties. Mr. Grable made several, suggestions as to how this equalization payment could be made, and it wasn't You know, as far as I know, the IRA accounts still haven't been split. So, no, that's not off the table. At any time, this can be done to affect the equitable distribution as it should have been done in the first place. And the second point I wanted to make was, you know, the point that counsel was making about alimony, how the court just sort of split the baby, right? He just picked a middle ground. He doesn't get to do that. The case law says that alimony must be based on need, and it cannot exceed need. And this is the Flans case and the Dorwith case. In both those cases, you know, the husband, I think this is the Dorwith case, the husband's annual income the last few years had been $500,000 per year. The wife's income had been $52,000 a year. They came up with what her monthly net income was, and they had awarded her $5,000 a month. And when they looked at the end of the day, they said, look, you know, you have shown a need of 53 or 57, but with the alimony that you've been given and your income, now you're getting 73. That exceeds your need, and we can't do that. That's an abuse of discretion, period. It's based on need. You don't get to pick a middle number. And if you don't have any questions for me, we would ask that you reverse this on the two bases that we've talked about today and ask the trial court to formulate a reasonable, equitable distribution scheme now and to reduce the alimony accordingly based on the former wife's needs.
Thank you, counsel. Thank you, counsel,
Thank
for
you.
both parties. We appreciate your time. The court is now adjourned.